event. My name is Emma Alonzo, and I'm the director of the Free Expression Project at the Center for Democracy and Technology. I'll be your MC throughout today's event. This year's theme, the Supreme Court's pivotal term, takes the important online free expression issues appearing before the US Supreme Court as the starting point for 3 days of discussions about online content governance, intermediary liability, and platform accountability, and what we actually want from the online services that we use and our broader information environment. We've got a lot of great conversations planned for you, with over 30 different speakers joining us from across the country and around the world. We're really excited to dig in, but just a couple of quick housekeeping notes before we get started. The Future of Speech Online will run from noon to 2:30 p.m. Eastern today, Wednesday, and Thursday this week. Just as a heads up, we are recording and live streaming all of the sessions on CDT's YouTube page, youtube.com/senddemtech. So if you have to pop out to another meeting or you miss a session today or tomorrow or Thursday, that's okay. You can catch up with everything you missed later online. We're also taking audience questions throughout the sessions. If you're connected through the Zoom webinar, you can use the Q&A function at the bottom of the window. And if you're following via live stream, you can submit questions via email to questions@cdt.org or via Twitter @senddemtech, or really across any social platform using hashtag CDT questions or hashtag FOSO2022. CDT's communications manager, Elizabeth Seeger, will be monitoring these channels and will pass those questions along to our moderators. We are really delighted to welcome a broad audience today and would remind all speakers and participants to try to keep our language as accessible and understandable as possible to allow people who are just thinking about these topics for the first time to follow along as easily as the people who are really thinking about all these things in depth. We will also have live closed captioning available through Zoom and on the live stream, and we'll be taking some short breaks between some of the longer sessions to allow our captioners to switch off. With that, I am delighted to hand it over to the President and CEO of CDT, Alex Givens, for some welcoming remarks.
Thank you so much, Emma, and it really is a pleasure to welcome you all to our 6th annual FOSO event. This conference comes at a particularly notable time for online speech, as the US Supreme Court prepares to hear arguments in the cases Twitter v. Tamne and Gonzalez v. Google, and perhaps to grant cert in 2 further cases regarding the controversial social media laws passed in Florida and Texas. We're looking at the most active term on online speech issues in the Supreme Court's history, including the court's first look at Section 230. Fittingly, today in particular is a pivotal time for this pivotal term. This morning, CDT filed an amicus brief in the Tamna case with a number of other organizations, the ACLU, EFF, Reporters Committee for Freedom of the Press, R Street Institute, and the Knight Institute at Columbia. I imagine that others dialing into this live stream today also may have filed briefs as well. In our brief, we're urging the court to understand how its ruling will affect a broad range of speech and speakers. This requires not only understanding the First Amendment doctrine at play, but the technical realities of hosting and providing access to other people's speech at scale. This focus on how the technology works in practice has been a hallmark of CDT's advocacy going back to the beginnings of the organization almost 30 years ago, when we helped to craft the proposal that ultimately became Section 230, and in the litigation that became RINA versus ACLU. We think it's essential for the court to understand the broad implications of its decisions, and we hope the conversations we'll host over the course of this conference can help in that endeavor. At the same time as CDT is working to inform pressing legal issues before the court, now is also a pressing time in the broader environment for online speech. There are important debates taking place about the best ways to fight hate, harassment, and disinformation online, and CDT is deeply engaged in this work as well. To give just 2 brief examples, this year we were proud to release new empirical research about online abuse targeting women political candidates of color. Research that gave evidentiary weight to many people's lived experience, finding that women of color who are running for office face 4 times the violent online abuse experienced by their peers. We published research about the practice colloquially known as shadow banning, finding that nearly 1 in 10 US social media users believes they personally have been shadow banned, stoking distrust and conspiratorial attitudes towards social media companies' approaches to content moderation. Importantly for us, these research reports and others don't just live on a shelf. We actively use them to inform conversations about content moderation practices, both with companies and policymakers in the US and abroad. And we're also working on further ways to increase transparency and accountability for companies' moderation decisions, leading a substantial body of work on researcher access to social media data, specifically how to support and increase meaningful access while protecting user privacy and ensuring that proposals will work in practice. If the important conversations about online expression taking place in the US weren't enough, the European Union, of course, is at its own pivotal moment with recent passage of the Digital Services Act. We continue very active advocacy through CDT's Brussels office, where CDT is the primary convener of civil society groups engaging on how the DSA will be implemented. We're grateful to do this work in partnership with so many others, including some of the speakers you'll hear from this week and some of the names I see in the online audience as well. This week's conference covers a range of timely issues. Today, we're going to dive deep in the cases before the court, but we'll also use this moment to discuss the broader landscape for platform accountability. If anyone is feeling the urgent need to talk about Elon Musk, I'm confident that that inescapable backdrop is going to surface as well. Today, we're going to start with an overview of the key legal and policy questions being debated in the courts and in Congress, with an exceptional panel moderated by the Washington Post's Cristiano Lima. Next, today, picking up on one much debated issue, we'll be joined by Jamal Green and Julia Wono from Meta's Oversight Board to discuss the new policy advisory opinion released by the board this morning regarding Meta's cross-check program, which has been criticized for giving politicians and celebrities preferential treatment in content moderation. We hope to discuss not only the merits of the advisory opinion the board is releasing, but the structure of the board as an accountability mechanism. We'll then turn to a signature focus of this annual conference, thinking about the real-world implications of content moderation decisions for different communities online. The panel will examine key threads and challenges that different communities face online, what is and isn't working in current approaches, and what impact the court's decisions could have on different strategies for fighting online abuse. We're going to fit all that into just the next couple hours, and then we're going to ask you to come back for more tomorrow. On Wednesday, we'll do legal deep dives on the Anti-Terrorism Act cases and the Florida and Texas social media laws, which are also likely to go before the court this term. And then on Thursday, we'll broaden our scope to hear from a range of experts from around the world, including a senior advisor to European Commission Executive Vice President Margaret Vestager, about how the US legal debates align with and affect the law and policy around intermediary liability around the world. We'll wrap with a final conversation about content moderation and must-carry laws throughout the stack. So there's a lot to cover, a lot to come. As a reminder to put on Emma's point, we're taking audience questions throughout the session, and we do hope that this can be a lively, engaging conversation over the next few days. A warm thank you to all of the speakers who are participating in this conference, and of course to the Stand Together Trust for their ongoing support of this event every year. We're really proud to host this timely conversation and expand on what's at stake in these critical debates. So thank you again, and Cristiano, over to you.
Thanks so much, Alex. Good afternoon, everyone. I'm Cristiano Lima. I'm a business reporter for the Washington Post and author of our Technology 202 newsletter. I'm thrilled to be moderating this very timely discussion on free expression online. As you've heard, the Supreme Court is set to take up two landmark cases in Gonzalez versus Google and Twitter versus Taamneh that could have sweeping implications for the future of the internet and efforts to police harmful material online, and could soon be reviewing more cases dealing with state laws targeting allegations of platform censorship, which could also test the limits of digital services legal protections under Section 230. To dig into these cases and what the ramifications could be for the future of the web, I'm joined today by Genevieve Lakier, Professor of Law at the University of Chicago. Genevieve, welcome. Jeff Kosif, Associate Professor of Cybersecurity Law at the U.S. Naval Academy. And also Yael Eisenstadt, Vice President of the Center for Technology and Society at the Anti-Defamation League. Thank you all for being here. So before we dig into the specifics of some of these cases, I'd like to start by discussing how we got here. We've seen challenges to the liability protections that digital services enjoy mount in recent years, both politically at the state and federal level and in the courts. I'd love to hear from each of you what you see as animating these types of challenges. What are the underlying concerns that are driving the challenges that we're set to see before the court? Genevieve, perhaps you can start.
Okay, well, thank you so much for having me at this panel. I agree that this is a really interesting time to think about the future of speech online. And in part, it is because of, to answer your question, Cristiano, it's in part a reflection of what's going on, what led the court to take up these challenges, which is really changing, I think, cultural views and attitudes about the internet platforms and about the nature of the digital speech environment. I mean, I'm sure the attendees to this seminar will be well aware of the shift in attitudes, away from the early tech euphoria to a kind of real concern that there's something terribly broken about the digital speech environment. And I think the courts are responsive to these transformations. And in particular, I mean, I think what's so interesting about the sort of free speech questions as they apply to social media is that they so often get refracted, but in a very weird way, through the kind of culture wars, polarization that's characteristic of so much of our politics and increasingly also our law. So it used to be, I think, that the court, and especially the conservative majority that has had control of the court pretty much from the 1970s, although the composition of that majority has shifted over time, were very pro a kind of free market approach to speech, and also speech online, that vested a lot of authority and discretion and immunity to large tech platforms and other large speech intermediaries online and offline, and thought that that was the best way to facilitate a healthy public sphere. And I think the conservatives on the court still have that view when it comes to the rest of the media industry, the offline speech, although I'm not entirely sure. There's been increasing rumblings about the immunity that publishers get under New York Times v. Sullivan to libel law. And so there's changing attitudes throughout about the entire media ecosystem among the conservatives on the court, both on the Supreme Court and among the judiciary and among Republicans in general. But it's been focused primarily on increasing skepticism that a free market approach to the regulation of online speech is the best way to have a healthy speech environment. And what is so interesting to me about this view is that in some ways it matches sort of progressive concerns about the rise of hate speech, the disinformation problem on social media. Both sides of the political spectrum are deeply concerned that there's something wrong about what's happening on the digital social media platforms, and that the corporations are somehow responsible, the private regulators of our media environment. But the takeaway, the problem that they identify is very different. I think people on the left think that it's that the corporations are not doing enough to heavily regulate speech. And I think people on the right think that they're doing too much, that they're acting in a biased manner, that they are taking down too much conservative speech, that there is some sort of deep structural problem here with the freedom of our internet environment. And so given pervasive dissatisfaction on both sides with what's happening online, I think it's not surprising that we are seeing renewed interest in the courts, both in litigation and then in judges, in taking up these challenges. And it's been interesting that the Supreme Court has stayed out of it for so long, given that this problem has been brewing for quite a while now. But it seems like the court is no longer willing to stay out of the conversation, the vigorous conversation that has been occurring both in the legislatures and in the courts for some time now.
Jeffrey L., would you like to jump in?
I'm happy to. Go ahead, Jeff.
Go ahead. Go ahead.
Okay. Sorry. That was a great overview, so I won't get into as much detail about the actual sort of moment that we're at in front of the court. But I want to take a step back a little bit. When you ask what has brought us to this point, I think part of the real issue is that, unfortunately, the public, many people in the public have seen that for so many years. Yes, we could talk about the whole tech industry. I think a lot of what people are really thinking about is social media in particular right now, is that social media companies, for all the good that they do, for all the good that they've done to elevate voices that would not have had a voice previously, for allowing more perspectives to surface, for connecting people around the world, all of these things, there have been consequences as well that just, for many of us, do not feel any sort of accountability mechanisms have been baked in. And so while I would disagree with both the left and right stance of politicizing this moment, I do think there's very real concerns for the ways social media, in particular, not the content that they host, but their own tools, their own designs, their own business decisions that at times have, for many people, in many people's opinions, and including in research and including in leaked documents that we've seen from some of the companies, and including my own experience from one working at Facebook, there have been design decisions, business decisions that have led to real harm. And I think part of that's why we're at this moment that people, and myself included and ADL included, are frustrated when over and over again, it seems like the courts have so broadly interpreted 230 that even in some cases where the question of whether or not a social media company played a role in, maybe, I'm not talking about the merits of any of these particular cases, I'm just speaking broadly, of maybe connecting illegal actors to other people online, and then they were connected through recommendations and committed crime, or whether, in this one of these cases, we're talking about whether or not a terrorist organization didn't just use the platform for speech, but was also amplified, recommended. We're not saying whether or not the platform is guilty. What we're saying is these are real world consequences that it feels like there's no recourse or no way to even get to the point of learning about whether the social media company had a direct role, because there's been such this broad interpretation of Section 230. So in just leading up to that, I'll say, ADL, we're also filing an amicus brief, not in support of either party, because we think it is crucial to first and foremost stick up for the part of 230 that I think everyone here agrees needs to be preserved, while also asking them to reconsider whether such broad immunity, not just for speech, but for actual actions that the platforms themselves take, if that status quo can continue any longer. And we just don't believe it can. So I'm looking forward to this conversation to unpack that a little more.
Jeff?
Yeah, so first, thanks so much for having me. And I have to just give the disclaimer that I'm only speaking on my own behalf, not on behalf of the Naval Academy, US Navy, Department of Defense. No one wants to take responsibility for what I say except myself, which is fine. So I agree with a lot of what's been said, particularly what Genevieve was talking about with the different criticisms, which is something that I've heard pretty much every day for the past 4 years since I wrote a book about Section 230. I had not anticipated that it would be figure so prominently in the debates, because it really did go under the radar for so long. And I think what's really changed has been the really outsized role that large tech companies play in everyday life. I mean, even when I started writing the book in 2015, they've taken on even more importance and more prominence. And Section 230 in many ways has become a proxy for the big tech companies. And they clearly do rely on it. And I mean, especially when you look at the cases before the Supreme Court, we're dealing with Google and Twitter. So those are big companies. But what gets left out of the debate, I think, too often is that they're not the only companies that rely on it. Anyone who operates a website, an app that relies on user content does benefit from 230, whether it's Yelp or Glassdoor or a local news site that hosts user comments. And interestingly, within the past few years, you've heard Facebook, Mark Zuckerberg testifying, we want to reform Section 230. And that's nice, but I also question, I don't know if it's just this big altruism, like, oh, hey, we're gonna take on more liability, or is it a recognition that the largest tech companies do not need Section 230 as much as the companies that want to compete with them? And I do worry, depending on whether 230 is changed in Congress or in the courts. I do worry about the harms, not for the big tech companies, because they will survive any changes, but I do wonder about the smaller platforms. And some smaller platforms are actually worse actors than the large platforms, but that are niche sites that have really harmful content. But then there also are a lot of small platforms that really are trying to do good and give people a voice. So I think there's a lot of complex issues out there. And I think also I would echo what Genevieve was saying about sort of the conservative critique of platforms, being concerned about moderation decisions that they have made. And I think fundamentally there are two very different visions of the roles that intermediaries should play in online speech. And I think there are some similarities if you almost go all the way around the circle, but I think there also are a lot of very big differences that are hard to reconcile. And I think we first have to come to a better idea of what the vision is for these online platforms. So anyway, those are my opening thoughts, and I look forward to discussing further.
Thank you all for that. So Genevieve, you touched on the timing of this and the notion that this has been these questions have been brewing for a long time. So these cases deal in particular with platforms' responsibility to police terrorist content. These are not the first cases that have dealt with these issues and how they intersect with liability protections. And it's been noted that this is not an instance where the lower courts flip on their rulings. And so that tends to be a good indicator of whether the Supreme Court agrees to take up a case. So I'm wondering if you all might be able to speak to what factors here might have contributed to the court deciding to review these cases. Jeff, maybe you can start.
Yeah, so I was actually pretty surprised. I had a Supreme Court litigator speak in my class the week before the court granted cert in the two cases. And she was asking, what do you think about the Gonzalez case? And I said, oh, no, there's not a circuit split. They're not going to grant cert. There's no way. And clearly, I'm not great at predicting. So I'm also not great at getting into the heads of the Supreme Court justices, because there actually were, I think, much better cases for the court to have taken over the past few years that I think presented much closer issues and issues where the courts have not had full unanimity. I think particularly the Herrick case from the Second Circuit involving sort of product liability theory of to get around Section 230. I had actually thought that was going to get cert granted and it was denied. So I don't know what would have caused the court to grant it in this case where there's not a circuit split, other than just what we've been talking about with just the increasingly prominent role that platforms play both in life and debate right now. I mean, you hear about it every time in the news, Congress holding hearings all the time. And the fact is that the Supreme Court has never heard a case to interpret Section 230. So I think it's hard to really distance the legal decision to grant cert with the pragmatic decision of how prevalent this is in the public debate right now.
So I'm sure many folks here are familiar, of course, with the concerns that Justice Thomas has raised with Section 230 in the past. But I'm wondering if there are any additional data points that you all think we might glean from the justices. Jeff, I know you alluded to it being hard to get in their heads, but in the spirit of tea leaf reading, what might we be able to glean from past rulings, past remarks that could give us some insight into how they're approaching some of these cases? Genevieve, would you like to jump in?
Actually, I thought I just wanted to add something to what Jeff said, because I agree. I was also surprised. No 230 expert. I focus more on the First Amendment, but this was. I think lots of people thought that this was these were a strange set of cases to take up, in part because there wasn't a circuit split, and in part because the facts of the case are very hard. I think if you would think that the court is taking cert because it wants to find liability here, this is a case in which there are. Like the questions of causation are very are very problematic. There is like no evidence that the actual the criminal acts were caused by the speech that was that there's a link between the people who committed the terrorist acts and the people who were posting. So in terms of sort of developing a good set of facts to make it make a sympathetic ruling that they can imagine there being more political will or more sympathies for a ruling that says actually liability doesn't apply here. I have a theory. I mean, one theory for why the court took cert in these cases is because it's an ATA case. And there was an an anti-terrorism act case. So it doesn't raise the ordinary questions that are raised by, say, a defamation suit or sort of the run-of-the-mill kinds of speech torts that 230 was meant to immunize platforms against. And one could read it, again, like Jeff, I have no special insight into the inside of the justices' heads. But there's a very well-known dissent by Judge Katzman in an earlier case, Force v. Facebook, which also involved an allegation under the ATA. And it was roughly similar. I mean, the facts were different, but again, it was this question about whether, and this is the question posed by the Gonzalez v. Google, whether when the platform recommends speech, it therefore loses its Section 230 immunity and therefore becomes liable under the Anti-Terrorism Act for either, if there can be shown that speech, the recommendation of that speech, I'm sorry, not the speech itself, but the recommendation constituted material support for terrorism or aiding and abetting terrorism, one of the pretty broad prongs under the ATA. And Katzman writes an interesting dissent in which he says he thinks that the Section 230 should not provide immunity in these cases because recommending speech, bringing people together in the online speech environment is different than simply publishing speech. And he also says in that opinion, which is interesting, that don't worry, those who worry about the viability of the social media companies, because this argument that it's about liability for recommending would not mean that you are now liable for defamation suits, for invasion of privacy suits, because all of those depend upon the act of publishing. And here we're not saying you're publishing the speech, we're saying you're doing something else, you're recommending the speech. And so its impact could be more limited than we might otherwise worry about. And so one way to read what's happening here, and this again picks up on something Jeff said, which is that both sides have critiques of 230, both sides have critiques of what's going on, and there might be some overlap. I wonder if there is a view, at least among some of the justices on the court, that at least when it comes to the relatively narrow question of terrorism speech and the ATA, whether we can carve out an exception from ordinary liability under 230 for that. Now, I worry about that because in some ways I would prefer a broader exemption, because then there'll be more political costs if the ruling is bad for the health of the platforms, and then there could be a political response. I do worry about a free speech jurisprudence that scapegoats terrorists and terrorist speech for its distributive effects. I worry that then everyone will be very happy that there's this carve out, and then certain kinds of groups will no longer be able to speak online and the majority won't notice. And I think that could be very bad for the speech environment. But if you were to read the tea leaves, I think it is quite significant and interesting that it is an ATA case, and that it might be therefore seen as a vehicle for a narrow exception to 230 liability in these kinds of ATA special cases.
Yeah, I'm gonna agree pretty largely with Genevieve's theory here. I mean, again, my understanding is that we're here to sort of set the stage a little bit as opposed to go deeply into the details of each case, which I understand will come later in this conference. But it was also my first thought as well as why this case. And because whereas, as someone who also spent the first 18 years of my life in the national security world, it makes it seem like it is an easier challenge when you're talking about speech, so-called speech from a designated terrorist group. And I could see the courts thinking that's their way of tackling this situation. I also agree with Genevieve. I don't know if that is the way that we would most like to see Section 230 discussions happen, because that doesn't talk about the broader context of what is going on. But I could see why they might think that this case would create a certain win. But I still want to keep taking a step back and really what is it we're talking about here? Because I think part of the problem is we get, for years, these conversations sort of come down to it's just too hard, or if we do this to Section 230, we're going to kill the whole internet, or if we do that to Section 230, no small companies will survive. And I think all of those arguments are valid, but they shouldn't be reasons to not have a more nuanced conversation about what is it we want to see on the internet in general, and what is it that we don't. And personally, and ADL as well, we don't want to see an internet where a company can, and I'm not going to get into the whole like business model, surveillance, advertising speech here, because I think most people here are very familiar with it already. But to be in a world where a company has so overwhelmingly relied on the idea that they're going to be immune from any accountability, to not actually take the bare minimum safety precautions in how they are, again, recommending content and how their targeting tools work. I mean, again, I'm not saying Gonzalez's case, we are not filing our brief on behalf of either side. But if you even look at reports, let's look at Facebook as an example. Reports of Facebook auto-generating ISIS pages. I'm not sure how you can claim that that is third-party speech. And I know from when I was there, the things that we were trying to work on often were rejected because there was this perverse incentive to not actually fix certain problems. So again, I'd rather have at some point these larger conversations of, but what would the world we want to create look like online? But we're getting, unfortunately, since this may not be the perfect case, we're stuck in a situation now where we have to debate the merits of this case as opposed to the larger, what would we like to see, if at all, in Section 230 changes. And I know for us, we'd like to see it updated to meet the reality of today. We are absolutely not advocating for getting rid of Section 230 or for major overhauls. That has never been our position. But some of that conversation I hope we're going to have as well.
So I wanted to follow up on that and a remark you made earlier. I mean, you've talked about thinking that Section 230 has been interpreted too broadly and sort of where to draw the line. You've all raised this question of the role that recommendation systems, algorithmic amplification should factor in. Yael, I'm wondering if you could speak to how you all are thinking about where that line potentially should be drawn, particularly when it comes to mitigating harms through recommendation systems and sort of like what platforms' responsibility should be.
Sure. So I also want to be clear that we are not, or at least we haven't to this point, sat down and said, this algorithm is good, that algorithm is bad. So this is where this all breaks down, right? Again, it is super difficult. Nobody is claiming that this is an easy answer. But we do, so I personally have said for years, even before joining ADL, that part of the problem is that we're trying to squish definitions into an outdated law for what we're seeing online today. And that's the whole, are we debating whether they're a publisher or a platform? Are we debating whether this is user-generated speech or not? And it kind of leaves out the whole point of how some of these companies actually operate, which is not what existed in 1996. And so I can't sit here and tell you exactly how different algorithms break down. I can tell you the perfect example from all of the released Facebook papers, for example. And yes, I know Facebook will say, well, that's just internal research. You'll always find research to dispute all of it. I think the Carol's Journey to QAnon thing from the Facebook papers is the perfect example of what we're talking about, and where we think that some form of rethink of what does apply to 230 needs to happen. In Carol's Journey to QAnon, you had this Facebook experiment. They created this woman's account. They made her this, I think, sort of conservative Midwestern woman, followed a few political accounts. Within 3 days, she's being recommended conspiracy theories. Within 5, she's being recommended QAnon accounts. I believe she's even being recommended into groups. These are the things that I question. Why is that okay? And now, again, not to say that therefore, if something happened and Carol went and committed a crime, we are saying we know Facebook is guilty. That is not what we're saying. But what we're saying is if that Carol in that hypothesis or in that experiment ended up committing a crime after having been recommended into a QAnon group and having met people in that group and they planned the crime together, is it a world we want where nobody could even consider trying to figure out, did Facebook play a role in that by leading her into that group and by connecting her into that group when she wasn't even looking for QAnon to begin with? And what we're saying is, we'll never even get there, because right now these cases are just being thrown out without any actual attempt at even discovery. So I know that people would like to take my comments as saying that I am saying Facebook is therefore guilty. That is not at all what we're saying. But we're saying that these rules for how they were written in 1996 do not apply to the reality of how these platforms operate today. And we just want to figure out, how can we update some of that? I cannot answer the question of exactly what kind of algorithm, what recommendation systems, but remember, every algorithm at its outset is coded by a human being with an intention in mind. And even though Facebook or YouTube or other companies might say, we don't understand why the algorithm did X, Y, or Z, they still set out with the goal in mind from the beginning, which we all know is the engagement-based advertising business model. So these are the things that just, if you think that that is all what they were thinking about in 1996 when they wrote these rules, and therefore these rules should never be updated, that's where I would just disagree.
So returning to the cases a little bit, I'm wondering if perhaps Jeff, you can take this. Could you talk through what the key questions that the court is set to take up in these two cases in particular? We'll circle back to the potential Florida and Texas cases, but in these cases, what do you see as the central debates that the court is set to weigh?
Sure. So there are two different related issues, two Anti-Terrorism Act cases, both involving claims under the Anti-Terrorism Act arising from ISIS shootings. And in the Gonzalez case, the question is personalizing third-party content and targeting at individuals, algorithmically targeting, in this case, ISIS content, is that protected by Section 230? So what the plaintiffs argue in the Gonzalez case is, we're not trying to hold Google, YouTube liable for third-party content, but for the act of targeting and therefore radicalizing people. And so far, there have been two dissents in the Second Circuit and Ninth Circuit cases that have argued that this sort of algorithmic targeting should not be covered by 230, but the appellate court, the majorities have held that 230 does protect it. In the Tomney case, that's where the court hadn't gotten to the 230 issue. There have been a number of Anti-Terrorism Act cases over the past 5 or 6 years against platforms, and most of them actually don't even reach Section 230. Most of them are like Tomney, and in these cases, the courts typically say there's not a sufficient causation, and basically on the merits of the Anti-Terrorism Act, that the platform is not liable. Now, in the Tomney case, the issue does a general awareness of terrorist content on the platform, is that sufficient to trigger liability under the Anti-Terrorism Act? And that raises some First Amendment issues. And I think this will be an interesting opportunity to see how the courts view these fairly old 1950s rules for distributors under the First Amendment, how the court views those as applying to modern platforms. We've had very few cases where courts have had to do that because we've had Section 230 since 1996. So there's a line of cases going back to 1959 that basically require at least some sort of state of mind of a distributor, for that distributor to be liable for the content that someone else created. And the case law is not, the case law basically says you can't have strict liability, which means that you can't be liable even if you had no idea about it. But the question is, at what point of awareness or what state of mind would allow liability under the First Amendment? Because what the courts are concerned about is that lowering the bar too much, that would basically have a chilling effect on legal speech, because if a platform could face liability unless it screens everything that it distributes, then it's going to distribute less content. So I think the Tomne case could be a really interesting First Amendment test case.
Go ahead, Genevieve.
I just wanted to add to that, because I think of Tomne, Jeff, it's interesting that you're so calm about it. I read the Tomne case as like a 5 alarm fire. I have to say,
I would agree.
Even like right now, thinking about that case makes me anxious. Because the legal issue involved in Tomne is, are you liable for serious penalties under the ATA as an aider and abettor to terrorism for simply not doing enough to get rid of terrorist content on the platform? And that rule, that's the rule that is being advocated here in the case that the court is going to be addressing. That rule is extremely worrying because it exposes platforms to incredible amount of liability, because there is a lot of terrorism content that's available, and how do we figure out whether the platform has done enough or not enough? In this case, there's evidence that the platform was trying to take down the terrorist speech, but was also aware that it wasn't doing the best job. And is that sufficient to establish liability? Now, I will just say, as a lawyer, I'm obligated to say, for aiding and abetting liability, because what we are talking about is the responsibility of one person for another person's criminal actions, the standard of intent, the mens rea standard, is usually very high. You have to specifically intend to help them do this thing. The ATA has established a especially low standard of pure knowledge, and this case would lower it even further by saying it's just not doing enough, really. Like, you know that you haven't done enough, but you're still trying to prevent this content. So it exposes platforms to incredible amount of liability, and we may say, oh, who cares? We want them to be more responsible, as Yael said, and obviously we do. But the worry there, of course, is that the response to a ruling that says you can have liability here is to immediately take down any speech that has any whiff of any liability under the ATA, and therefore to chill a tremendous amount of what we might imagine is actually protected expression. And so Tomne seems to me an incredibly scary case that the court even chose to take cert on this, because from a free speech perspective, not even a First Amendment perspective, I would imagine all members of the court should recognize that to say that this theory can hold up is an incredibly worrying view. Now, maybe Jeff's right. Maybe they took it because they want to talk about the First Amendment limits in these cases. I don't know. The court has shown no interest in going back to these early, very interesting but very narrow rulings like Smith v. California about distributor liability. And so I guess I'm not worried. Again, I kind of think that they took these cases, which are conjoined, the Gonzalez and the Tomne cases, because of the ATA issue. And maybe the more likely outcome is they're going to limit 230 liability in some way, but then say the ATA does not go that far, because that would be crazy, and they never get to the First Amendment issue, which is possible. But Tomne is an incredibly worrying case, and I think anyone in the room, in the audience, who cares about free speech should be worried about that case.
So when you talk about being worried, I think that suggests trepidation about what the outcome could be. Could you speak to what you see as sort of the range of outcomes that we could see the court take, and what are the implications of those for free expression online?
So again, I'm no 230 expert, so I will just defer somewhat to Jeff here. But again, in reading the tea leaves, the court clearly took this case because it's interested. There are significant members of the court who are interested in limiting 230 liability in some ways. And I assume that they took this case because they think that it provides a good vehicle for limiting 230 liability. Now, I might be wrong. It is completely possible. And one of the things about the weird politics of the Supreme Court right now, which is that both the left and the right have concerns about the current state of online speech, but on the other hand, have very different concerns. It might be that those concerns essentially cancel each other out, and what happens is just a reaffirmation. I think this is absolutely within the realm of possibility, a reaffirmation of the existing status quo, that the court takes us just to smack down any possibility that there could be an exception in these cases, and to finally get rid of what has been, I think, for a long time now, a kind of murmuring that maybe Judge Katzmann in his Force v. Facebook dissent was correct, and this is a viable path forward. So I think one of the possibilities is to end that possibility and just reaffirm the status quo. I think the other viable possibility is that the court says, we're going to follow some kind of limited we're going to carve out some of Section 230 immunity for platform recommendations, for boosting. But of course, that's worrying because so much of what platforms do involves recommendations. And so I assume that paired with that is going to be some language about how this doesn't mean that there's no liability for defamation, for ordinary speech torts, for the run-of-the-mill 230 cases, because in ATA cases, we're talking about your liability as an aider and abetter, a material supporter. We're not talking about your liability as a publisher. And so this is just a ruling for basically for the ATA and similar kinds of specialized statutes. I think that's maybe the most likely. And then on the other hand, I mean, and also in the range of possibilities, the court could just destroy 230 and say, we're going to have a carve out for any time that the platform recommends or boosts. And because that's different than simply publishing, and we recognize that. And the court may think that that's not destroying 230, but because so much of what social media companies are doing is involved in curating, sorting, promoting, I think that would be an incredibly huge, that would be an enormous carve out. And so the sort of economics of social media would look very different. My intuition is that that is not what the outcome is going to be. I know that there are people who are worried about that, but the court doesn't typically want to destroy major American industries. So I don't think it's going to go that far, but we live in strange times.
I agree with everything Genevieve said, and I would add one more bad scenario, which is, so 230 is always seen as being really broadly interpreted, and that comes from a 1997 Fourth Circuit case, which was the first federal appellate court to interpret 230, written by a very respected judge. And basically, everyone has followed this ruling, which basically says even if the platform is told and knows about illegal defamatory content, as long as it's not violating federal criminal law, the platform could be protected by 230. And that has never been something that, and so pretty much every federal appeals court has agreed with it. But I also see this as possibly the worst case scenario would be the Supreme Court basically using this as the vehicle. It wouldn't be a great vehicle, but this is the first time they're looking at it. They're not bound by the Fourth Circuit's 1997 ruling, so it'd be a very unfortunate outcome. But I do think I think, and again, it's hard to predict what the Supreme Court will do, but I think that basically exempting algorithmic promotion of content is perhaps a bit more likely. I think the reason why I think that is, that's where I could see some alliance between the liberals and the conservatives on the court, because for the liberals, they might want to say, we want to go after really bad acts, and we think that in this case and other cases, certain types of algorithmic promotion are very dangerous. So I think you might get votes there, but I also think you could get conservative votes beyond just Justice Thomas, for people who want to say, this might be a way to limit, to discourage the platforms from exercising too much what they view as editorial control, have them take more of a hands-off approach, and imposing liability for algorithmic promotion and curation, or at least getting rid of the 230 shield, might promote that. And I think that actually, I think if that were to be the outcome of the case, I do think that you would very likely have more harmful content online, because the platforms would be discouraged from using algorithms. And while there are some bad uses, obviously, I think that it could very well make a lot of these platforms far more dangerous.
So I wanted to just again plug that we have the Q&A coming up, so get those questions in for our panelists. So I want to turn over to the Florida and Texas cases, which have not yet been taken up on their merits, but we could see that. And Jeff or Genevieve, perhaps, and anyone can jump in. What are the sort of central questions there, and what are the implications that the court taking on those cases could have for expression online?
I'm happy to talk about that. So there are two cases that it seems likely that the court is going to take cert. We don't know, but they're sort of the opposite side to the 230 cases, because the 230 cases are all about exposing the platforms for to liability for keeping speech up. And these are cases involving laws that require the platforms to keep up speech even when they don't want to. So the fact that the court could end up hearing all 4 of these cases in either 1 or 2 terms really shows the very bizarre politics going on right now, where there are pushes both to require the platforms to keep up more speech and pushes for them to take down more speech. And both of those have, I think, constituencies on the court. So the net choice cases involves a law coming out of Florida that imposes transparency and due process obligations on the platforms, and also requires the platforms to keep up the speech of political candidates for a period before the election, even when, I mean, the Florida law is quite far. It's an absolute requirement that you have to keep up the candidate speech, even if they violate the platform rules, and that's just the rule. And then in Texas, it's a somewhat different rule law. It involves similarly due process and transparency obligations, but also a ban on viewpoint discrimination, and this by the social media platforms. This doesn't involve just political candidate speech. It's every user on the platform now has a right against viewpoint discrimination that Texas has imposed. And so they raise, I think, so many different First Amendment questions. I think the free speech community is very intrigued, excited, concerned, all emotions about these cases, because they're going to be, I think, maybe the biggest First Amendment cases that the court has heard. So certainly about online speech, maybe since Reno in 1996. And so it's very significant. And that's why I think the First Amendment scholars and litigators assume the court is going to take certiorari.
Would anyone else like to jump in?
I mean, I'll just say quickly, again, I don't want to, I was understood that we won't be getting into the details of each case in this panel. So yes, I mean, I agree with a lot of what they said. There's some cases that are coming up that are super concerning, and ADL shares the same concerns. I just want to bring it back to one other point that I forgot to make earlier. There is no world in which any sort of change to Section 230 in and of itself creates this safer internet that many people, I think most people, have a similar North Star on. And so part of what's interesting is when we talk about wanting to update certain parts of Section 230, we are strong advocates for having, this is separate from Section 230. It's the idea of what does transparency look like for these companies, and not just transparency for transparency's sake. In order for us to continue to be able to study the actual effects of whether it's recommendation engines, whether it's other kinds of algorithms, whether it's targeting tools for advertising, whether it's auto generation of pages, the only way we can truly study those to truly understand whether or not the platform played a role in the real world offline harm that occurred is if there is more transparency, access to data for researchers or for oversight bodies, the ability to actually study these things in a very much more transparent way is part of what can contribute to a smarter way to figure out what is the right set of guardrails, rules, and regulations that should be updated to fit 2022's online reality. So to be really clear, that is our biggest push, is for more transparency requirements, because right now a lot of these conversations about what 230 will or won't do, about what a platform's responsibility or direct role in anything is happening in somewhat of a black box, because we only know as much as we have access to, right? I mean, we at CT, at the Center for Tech and Society that I had at ADL, we've done research for years into whether it's through qualitative surveys or quantitative research into how recommendation engines work, into, I mean, the one we did this past year on YouTube, and exactly how their recommendation engines were pushing people and recommending them to extremist content. All of these things we study, but we won't be able to get to a true answer on what everything should really look like without better access and transparency into any of the things that I think we all want answers to.
Well, I guess I should say, just in response to that, I didn't mention it earlier, but the Texas and Florida laws, they raise 2 sets of questions, both of which are really interesting and important. The first set of questions is about, can the can legislatures impose obligations, must carry obligations on platforms to carry speech? And that's enormously controversial, and I'm happy to talk more about that in the Q&A, but I'm going to leave that aside for now. But the laws also do impose all these transparency obligations. And so one might see these cases, if the court takes cert, as a real opportunity for the court to articulate the standards that should apply when legislatures impose transparency obligations on platforms, which does seem like a very important way forward when we're thinking about social media regulation.
Just to quickly add to Genevieve's great summary of the cases, if the courts, I think it will go to this. I think both cases will go to the Supreme Court. If the Supreme Court strikes down the Texas and Florida laws, it could do so either on First Amendment or Section 230, or both. But if it upholds them, it's going to have to address both. And so this could have not only First Amendment implications, but pretty huge Section 230 implications about how much does Section 230 protect the ability of platforms to moderate. And the Fifth Circuit, I think, its analysis of Section 230, I think, was quite flawed in terms of how it interpreted the second part of Section 230, but I think that would be a really big challenge for the Supreme Court.
So we're going to turn to audience questions in just a couple minutes, but I just wanted to take another step back on these two cases. How do we see some of these same debates, particularly around the transparency question, playing out more broadly at the national level? And how do we think that Supreme Court decision potentially in these cases could affect those or influence those? And I'm happy to open that up to the group.
I mean, if the court comes out with a clear standard on the rules that apply of the First Amendment rules that govern transparency obligations imposed on platforms, and if, as they could, I think, because I think this is an area where there might be consensus on the left and the right of the court, that we should have a rather deferential standard when it comes to laws that are promoting disclosure, because this only advances sort of the consumer interest in knowing what they're getting in the platforms. So there is arguments that the platforms should be held to a standard that's quite low that applies to commercial advertisers. I think it's going to give the green light to legislatures around the country to start experimenting with different kinds of, I mean, they clearly already have a green light or a yellow light, but it's going to only encourage that more. And so I imagine that we could see that this is just the beginning of a huge swell of lots of state level experimentation. I mean, Congress could get involved too, but right now that seems, at least right now with the current politics, seems unlikely.
Yeah, I mean, we've seen this already in California, right? With bill in California, which, you know, ADL was a big part of. The question is, to Genevieve's point, on transparency in particular. And again, I always want to just clarify, not transparency just for transparency's sake, right? Transparency so that consumers know what is actually happening with the platforms that they are using. Transparency that leads to actual informed decision-making. Because right now, a lot of our policy decision-making is not happening based on being fully informed about what we are actually looking at. So sure, if this pushes the hand a little bit more for federal legislation, that would be fantastic, but states will continue, and we will continue to push for states to consider really strong, good transparency legislation as well.
So I'm going to turn over to some of the audience question that touches on this very point. So broadening it out from transparency, someone asked, if the Supreme Court significantly curtails Section 230 in one or both of the cases, how do you expect that will affect the conversation about 230 reform and platform policy in Congress, if at all? What do we think?
I mean, I think we'll probably still have a lot of the same sticking points that we have now when it comes to Congress, because I think while everyone's angry at the big platforms for various things, I think that what they want to accomplish, I think transparency, I agree with Genevieve and Yael. I think that is an area where you might see more agreement on the left and right, but in terms of the actual content moderation and what gets taken down or left up, I don't know if that gets us any closer. I think the debate will still be the same. You're going to continue to have proposals to somehow condition Section 230 on the removal of constitutionally protected speech, and you're also going to have proposals to require platforms to keep up speech. So I don't know if that really moves anything in Congress.
I mean, I guess I worry that if we get a 230 ruling that is just about terrorist speech, it's going to be part of a long tradition in the court's free speech cases in which we're just going to treat sort of this broad category of, I don't want to call it terrorist speech, sort of like speech that is somehow could be construed as in favor of sort of political extremism that is associated with groups that we are on the terrorist watch list, or you might think including the political speech of political organizations like Hamas, that we're just going to treat them as exceptional for free speech cases and give them less protection, and no one's really going to be bothered by that limitation. I'm thinking here of the Hold of a Humanitarian Law Project decision, in which the court again says we're applying ordinary First Amendment principles and doesn't. So I guess I think that there is a way out, that the court could reach a ruling here that doesn't actually have much political costs for it, but is still maybe problematic when we think about free speech and sort of chilling effects on platforms. But hopefully the court is going to do something that is going to, you know, help help the political conversation around 230. But I agree with Jeff. I think we've got intractable political differences that are not going to go away anytime soon.
So another question we've gotten, how is the argument that a platform's algorithm can lead someone to extreme viewpoints acts any different from arguing that the platform's editorial algorithmic decisions are just too persuasive? Would anyone like to take that?
I'm not fully sure that they are different. I'm not sure if I fully understand the question, but if the question is, are we just arguing that the platform's algorithms are too persuasive? I think that's very broad, because at the same time, right, we do agree that we're not trying to get rid of all forms of curation online. Like that I don't think would benefit anybody right now. We just see nothing but spam and things that we don't want to see. So I think it's less about whether or not they're just too persuasive and more about whether or not some of these tools actually help facilitate a crime. And that's one of the concerns. And, you know, we keep talking about that part, but we're not talking about as much about the part of Section 230 that we want to see preserved. We want to encourage companies to do responsible content moderation, right? And so that's why this is so tricky, because you have two different goals within Section 230. And we want one of those two goals to be updated, and we want the other one to be preserved. And that's where a lot of this gets very complicated. But if I understand the question correctly, it's less about whether or not algorithms are just too persuasive and more about particular instances where a platform's tools specifically aid and abet in a crime. And I get that people will say, and if you even tackle that, then it will chill all sorts of things online. And it's very hard to accept that there's always going to be trade-offs, but that sort of smacks of the we do more good than harm argument. And for those who are actually harmed, I don't know that that argument really should continue to stand.
I mean, I guess I'll just say, as pushing back a little bit, you know, and this is why I find the terrorist speech cases and cases like Holder really hard. I think the argument is that you are aiding and abetting terrorism by facilitating persuasion often. I mean, that's not the only argument. The argument is also that the terrorist actors use the platforms to mobilize, to organize, not necessarily to persuade. And therefore, that's how the platform is aiding and abetting. But in these cases, it is that you are introducing, you are facilitating the spread of ideas. And I think the real difficult First Amendment questions that the court, I think, has done a terrible job of answering is, how do we think about these First Amendment values in this kind of context where there is the threat of mass violence at hand? And the court has been unwilling, I think, to recognize that when we talk about material support for terrorism, when we talk about aiding and abetting terrorism, in many of these cases, we are talking about kinds of activities that have traditionally been understood to be fully protected.
We've gotten a couple questions about how might you distinguish targeted recommendations from recommendations related to the Gonzalez case?
I think it's hard. I think that because I don't know how there could be, and perhaps there could be, but in a Supreme Court opinion, I don't know how they can make an enduring distinction that would last not just past this current technology, but through new iterations. So I guess I think it is helpful to look at 1996. And while the technology has changed greatly, when you look at what was the reason for Congress passing Section 230, it was because there was an online service that faced more liability because it did engage in curation. It used technology a lot. Some of it was automated, some was human. And the idea was, we don't want to discourage this. We don't want to discourage platforms from taking a hands-on approach. So perhaps this is something that people say, we don't want to have this rule anymore. But I do think that the principles that Congress had in mind back in 1996 are quite relevant today, and we do need to consider them and what the impact would be when we start changing them.
Well, thank you so much to all the panelists. Unfortunately, we are coming up on time. Clearly, we've only scratched the surface on a lot of these topics, but luckily there's a slew of other panels that'll dive into different aspects of this in more detail over the coming days. And thank you to everyone to submitted questions and for having me today. With that, I'll turn it over to our next speakers. Thank you.
Great. Thank you so much, Cristiano, Yael, Jeff, and Genevieve for that excellent discussion. I know we did not manage to get to all of the great questions in the Q&A, but fear not, we will have 2 legal deep dive panels happening tomorrow from noon to 2:30 p.m. So if you didn't get your question answered today, please do come back for those conversations because we'll have a dozen lawyers ready to dig into them and really explain all of the nitty-gritty details in depth. But thank you all so much for that conversation. We are going to take a very short break right now to set up our next session and give our captioners a chance to trade off. So we will see you back here in just about 2 minutes for our next conversation, which will be a deep dive into the brand new policy advisory opinion from the Meta Oversight Board. We'll be back here at about 1:12 p.m. Eastern Time. See you then. Hello, everyone, and welcome back to the Future of Speech Online. I am excited to welcome to the virtual stage our next guests, Jamal Green and Julie Owono. Jamal is the Dwight Professor of Law at Columbia Law School, where he teaches constitutional law, including the First Amendment, and is a frequent media commentator on the Supreme Court. Julie Owono is the Executive Director of the Content Policy and Society Lab and a Fellow of the Program on Democracy and the Internet at Stanford University. She's also the Executive Director of the digital rights organization Internet Sans Frontières. Jamal and Julie are also both members of the originally Facebook and now Meta Oversight Board. Jamal serves as a co-chair of the Oversight Board, and both Jamal and Julie have been deeply involved in the development of the brand new policy advisory opinion that we're here to discuss today. So welcome, Julie and Jamal. To get us started on understanding this new policy advisory opinion and kind of what it means, what its implications are, I'd like to turn first to Julie. So the Meta Oversight Board has been active for about 2 years now and has issued only, I think, one other of these PAOs, policy advisory opinions. Can you give us a quick introduction to the work of the board and what it's trying to accomplish with an advisory opinion like this, and kind of how has it been going over the past 2 years?
Yeah, sure. Thank you so much, Emma. It's a great pleasure to be back for this amazing conference, which I always look forward to at the end of the year. So the board has been indeed operating for the past 2.5 years now. And well, most of the public would know the Oversight Board through its individual cases, through which we make decisions on the content moderation practiced by Facebook and Instagram on content by individuals. But aside from that, the board also looks at broader policy issues that the company Meta might be facing. The first PAO that we worked on was related to private residential information, whether or not the company should be allowed to share those or should allow people to share this information, and if not, why not? And so we made a set of recommendations. And what's interesting with the policy advisory opinions, and we'll get to that with the specific one, is that it allows the board to look at things in an even more systemic manner, not just focusing on one case, but really looking at the policy and the potential trade-offs that need to be made. But we'll get further into that in the discussion about the cross-check PAO.
Great, thank you, Julie. So this cross-check PAO, the policy advisory opinion on the cross-check system that's at the focus of this opinion was pretty controversial when it was first disclosed, because it basically appeared to be a system that gave preferential treatment to politicians and celebrities and major brands that operated on Facebook and Instagram, if not applying lower or kind of more permissive standards to their posts, then at least giving them a second bite at the apple, giving them the benefit of a closer look by content moderators at Meta before action would be taken to remove their content or deactivate their accounts. So sort of alluded to in the big oversight board case around the decision by Facebook to take down Donald Trump's account. And then more information was sort of disclosed in some of the Frances Haugen leaks. So Jamal, could you tell us, what did the board find in your review of this system? What were the key kind of recommendations, and how do you think about a system like this? Like, is it inherently just something that benefits the privileged, or is there kind of a broader benefit to other users that might be possible from that sort of system?
Sure, I'm happy to get into those questions, but first want to echo Julie's thanks for hosting us, and pleasure to be part of the conference. As to the policy advisory opinion on crosscheck, the basic bottom line is that Meta does have processes through which they subject different content from different users to a different kind of review process. And in order to do that in a way that's consistent with the company's human rights commitments and also with the company's values, the company needs to do that in a way that systematically prioritizes expression that is valuable from a human rights perspective. So cross-check is a more contextual, higher level review for certain users and certain content. And that the idea behind it is to prevent so-called false positives. That's content on Facebook or on Instagram that the company's sort of at scale review initially flags as violating, but that doesn't violate the company's content policies ultimately. And so there are a lot of benefits associated with being subject to this kind of system. There's delayed enforcement, so that it takes longer to enforce against a potentially violating content. That delay might be very significant in terms of the virality and engagement with the content. The cross-check also gives sort of contextual exceptions that can only be applied at escalation with higher level review. And there's, as you say, a more careful scrutiny from a higher level and often more knowledgeable reviewers. Now, having a system like cross-check in place in itself is not all that surprising given the scale of content that Meta reviews. But again, in order to honor the company's values and uphold its human rights commitments, it needs to be very careful in the way in which it does so. So what the board basically says is that expression of the journalists, human rights defenders, expression that's of real global importance, not just to the speaker, but to the audience as well, and that may be of high risk of false positives, should not be competing for cross-check resources with celebrities or with the business partners of the company who are on the list mainly to prevent certain kinds of reputational risks to the company. So more specifically, again, prioritize users who are likely to produce expression that's important for human rights, have clear criteria for eligibility, and even allow eligible users to try to apply to be added to the program, publicly mark certain entities, so be much more transparent about who's getting cross-check and who isn't. Right now, what the company does is it defaults to keeping things up on the platform if you're part of cross-check. There are some benefits to that if you think cross-check is really, really necessary, but for certain kinds of high severity content, the policy advisory opinion suggests that content should be removed or downranked while pending review. There's also some recommendations around sort of auditing and tracking error rates and various metrics to use. But those are the basic recommendations.
Yeah, that's really helpful. And I should flag for folks that this policy advisory opinion is now available online as of today. So you can take a look at it. It's, I think, close to 60 pages. So there is a lot to dig into with it. But I thought it was really interesting, the sort of this tension that was highlighted with the cross-check system of, on the one hand, providing more careful searching review, making available these different kinds of exceptions that apply when the full context of a comment is taken into account. That's kind of what we want for all speakers. We want everybody to be able to benefit from that. But then also you really do a great job in the opinion of talking through the downsides of the kind of the delay that is built into something like the cross-check system, where it can take 3, 4, 5 days for a final decision to be made on content that, at first blush and at final review, it turns out to be some pretty abusive content, or content that might really cause a lot of harm or drive a lot of harassment to different users in that, the time that it's still kind of left on the service. So I'm interested in hearing kind of how you think about a company like Meta at scale, like really trying to balance these trade-offs, and how feasible is it to give that sort of more searching review to more or many more speakers, or what sort of prioritization questions did you have to grapple with?
So I don't know if that's me or Julie, but I'm happy to jump in, and Julie can tell me where I've gone wrong. I think as a general matter, it is really challenging. And of course, as you say, Emma, in a perfect world, you would have high level contextual review for every user on the platform. But when you're talking about hundreds of millions or billions of people and posts, that's just not practically feasible. And you can imagine situations where, if you imagine the sort of purest of motives for any social media company or platform, that there might be a human rights organization that's trying to expose abuses, or there might be a newspaper story or something, which are really prone sometimes to false positives when you do really broad scale enforcement, and you don't want that kind of content to be taken down from the platform, or take several days for an appeal to happen, for example. But on the other hand, you also have to be very careful about exactly how to make those kinds of calls. And so what the board really looked at is not so much which users are sort of entitled or VIP kind of users, but what kind of content is it really important for global discourse to remain on the platform and not be susceptible to false positives. And that can be hard to define. Certainly on the margins, it can be hard to define. But we offered some of the core examples of that. Certain kinds of political speech, certain kinds of speech by journalists, speech by human rights organizations, for example, as a guidance for the company, where you can think of those as being on sort of one end of a spectrum, and a sort of an advertiser who might be on the current version of Crosscheck on the other end of the spectrum, where as a business the company may want to reduce reputational harm, but again, there are resource constraints in how to do that, and that shouldn't be competing with this other kind of speech that's much more important for global discourse if the company wants to honor its human rights commitments as it's committed to doing.
And if I could quickly jump on what Jamal just alluded to about the importance of human rights discourse, the importance of discussing democracy, the importance of discussing freedom. We know and we see how complicated that can be in the current social media environment and social media governance environment particularly. But nevertheless, this is the strength of social media platforms. We all remember Mark Zuckerberg at Georgetown University reminding us that contrary to popular belief, he worked also on this platform to allow for voices to be heard and to allow for human rights violation, democracy defenders really to be able to express themselves and not this is what the PAO does. I think it's a very interesting exercise, very difficult. You've said it, close to 60 pages and a little over a year of discussions, roundtables. But I think this exercise is a great opportunity to remind that it is possible to strike that balance. Not easy, but it is possible, provided that you put in the necessary work, the necessary conversations, the difficult ones as well. And most importantly, that you involve the stakeholders who might be concerned by the decisions that are being made or not made through the Crosscheck program. So just wanted to add that. Thank you.
No, yeah, thank you. So we've got a couple of good questions already in the Q&A. We definitely encourage people either following along on the live stream or here in the webinar view on Zoom to send in questions. A great one that's come in from an anonymous attendee asking for our panelists, do you have any information or statistics about where geographically the process is most used? Is it more so used for US-based users or English-speaking countries? And I know there's some interesting statistics about this in the opinion. So can you let us know what you found when you looked sort of proportionally around the world? Where is Crosscheck actually being used, or was it being used by Meta at the time?
Well, I'll start, and there are some statistics in the opinion about this, and they do suggest that the Crosscheck is used disproportionately. At least the Crosscheck list of certain entities is used disproportionately in the United States and Canada, even though there are only 9% of users. Something like overall users, only something like a third of the Crosscheck entities are from those regions. And this really highlights one of the major issues here, which is that there are lots of reasons to think that there are problematic false positives and content that is wrongly removed in lots of other regions, but those regions are not regions where users are as likely to have connections to the company or involve financial risk to the company. And so those kinds of false positives don't get the same kind of attention, and human rights commitments and the company's values themselves don't suggest that speech from regions where there are wealthier or more connected users should get privileged. And so that's really the bottom line, one of the bottom line recommendations that the board makes in the case.
And if I could, refer to one particular data that kind of shocked me personally, it's the fact that for cross-check content to be moderated, a cross-check content by a user in North America, Canada, United States, it takes about, I think, 12 days, can take about 12 days. Whereas in Afghanistan, where we very well know the situation from a human rights perspective and from a democracy perspective, it could take, and Syria, it could take up to 17 days, really showing sometimes the inadequacy of the choices that are being made. And quite frankly, the danger that such policy can pose for fragile societies such as the ones in Afghanistan and Syria at the moment.
Yeah, and I think this must also get into really significant questions for Meta or any other platform about, prioritizing resources for different parts of the world where we know there are really particular human rights risks at issue, and understanding the local context is so crucial, and being able to kind of understand language and how it's used in the local context, and how much of that can be automated, how much of that do you need staff in place. So I feel like the kind of recommendations from this advisory opinion feed into a lot of the other conversations and sets of recommendations that have been put before the board. I did have a couple more questions, and again, folks are welcome to send in questions through the Q&A feature as well, but a little bit more around kind of the process of putting this PAO together. I think this issue about cross-check has had somewhat of a bumpy path getting to the oversight board and this policy advisory opinion. As I mentioned at the top, cross-check was first sort of revealed in a way that I think confused and surprised a lot of us in the oversight board's case around Trump's account, and then was a feature of the Frances Haugen leaks. And there was actually even kind of assertions in what Frances Haugen was, the information she was providing, that Meta had hidden or given incorrect information or impressions about the cross-check system to the board. So how does that affect the relationship between the board and Meta? How do you determine after something like that, kind of what credence to give information that's coming to you from the company?
I will go ahead very, very rapidly. I think that that sequence of events was very interesting, and it shows the extent to which the dialogue that the board is having with Meta is very public, and that publicity allows maybe for, from my perspective, probably a more frank conversation. What is interesting with this particular PAO is that the company, sent that request to the board in a very complicated moment for it, right around the Facebook files revelations. But I think that it has been quite of a push, frankly, because the company has shared thousands and thousands of documents with the oversight board. The board asked more than 70 questions to the company, and the company extensively briefed the board. We had, I think, 4 briefings on that particular cross-check PAO. And in addition to that, of course, we did a global stakeholder engagement, as we always do, and we also received public comments, including from the Center for Democracy and Technology. So all this to say that this moment has been a very interesting exercise in transparency and disclosure, and probably is a unique opportunity to have information that were not that public before. I'm not saying they were concealed, probably not, but at least they were not as public, and we were not having as public conversations about them. So I would say it's difficult. We can never be totally satisfied, but that's not the point. The point really is to make sure that finally, as our executive director always says, Thomas Hughes, opening that black box of content moderation. And I think that PAO is yet another very good exercise into that.
I completely agree with Julie, and just wanted to amplify just that the way in which this process has worked. It's been an evolution, I think, in the relationship between the board and Meta, and the degree of forthrightness of Meta towards the board is a work in progress. It evolves. It's better than it was. We got a lot of information from Meta on this process, and ultimately, when you kind of look at the big picture, is you start with the Trump decision and the initial revealing of the existence of the board. You get the Frances Hogan revelations, and suddenly we know so much more about this kind of process because of through the policy advisory request and then report than we did before. And that's not just beneficial in terms of Meta and what Meta does, right? Our measure of success is not just whether we kind of land criticisms of Meta, it's also whether we can offer guidance and a blueprint to the industry and to the world for how to uphold human rights commitments at the same time as you moderate content at an enormous scale, right? So this is why the report is public, right? And anyone can pick it up and read it. It's not just sort of internal advice to Meta, and I think that's a really important function of the board.
Yeah, I definitely have to agree there. I think at CDT, as we've been watching and contributing case kind of opinions or amicus briefs into the different opinions and cases before the court, and watching this experiment of this oversight board unfold, it really has struck me that the opinions that you all put out have some of the most concrete working through of what it actually looks like to try to apply human rights standards in practice to large scale content moderation decisions. You know, a lot of folks in advocacy and academia have been thinking and talking about this, but as far as kind of boiling things down into case studies for regulators, including regulators around the world who are passing laws requiring, as one of our audience questions pointed out, you know, something that looks like an oversight board model, but for every user, for every social media platform, for every decision, potentially, to be able to go and get a hearing or get some sort of review of a decision that a company makes about their speech. Having the kind of concrete thinking through and examples coming from the oversight board, I think, are really, really crucial, because people might not always agree with every outcome or agree with every set of recommendations coming from the Meta Oversight Board, but you all show your work and you lay out kind of what the trade-offs and considerations and the real kind of practicalities of protecting human rights at scale could really look like. So I think we are unfortunately out of time for this discussion. Thank you both so much for joining us. I know that there's a lot more to dig into about the PAO. We really appreciate you coming out to FOSO to share some thoughts about it. And I know the Oversight Board also has other discussions and feedback sessions planned. So folks should keep an eye out for that and opportunities. I'm guessing Julie and Jamal are off on a whistle-stop speaking tour about this opinion. But for now, I will thank you both so much for joining us and start to welcome our next set of panelists. So Jamal Green and Julie Owono, thank you very much. And now, to keep the conversation going, you do not get a change of moderators. I'm just going to keep things rolling. I'm very happy to welcome our next panel, who's going to help us put everything that we've heard so far today into the broader context of policy debates around content moderation, platform accountability, and the struggles that real people experience as far as facing and fighting abuse online. For this next panel today, we are joined by Devin Hankerson Madrigal, who is our very own research manager here at CDT, and who is a remarkable advocate for improving technology access to expand individual rights and for ensuring that more people share in the benefits of technological progress. We also have Kate Klonick, an associate professor of law at St. John's University Law School, who has done both legal and empirical research on the content moderation processes within major online services and documented the development of these new governance systems for our online speech. And finally, we're also joined by Matt Peralt, who is the director of the Center of Technology Policy at UNC Chapel Hill. He's also a professor of the practice at UNC's School of Information and Library Science and a consultant on technology policy issues at Open Water Strategies. Matt also brings a perspective of having worked inside a tech company where I first met him many years ago, and that really kind of provides interesting perspectives to the conversations around practical and implementable policy considerations. So I think we've got a lot to potentially talk about. We've already heard a lot today. Thank you all so much for coming on and helping us make sense of all of this. We, once again, invitation out to all of our listeners, both in the Zoom and on the live stream. Please do send in your questions for this panel, either through the Q&A function on Zoom or using the hashtag FOSO2022 or to questions@cdt.org. So I think I want to turn first to Kate. So we just heard from Oversight Board members Jamal Green and Julia Wono about this new policy advisory opinion that they've issued on Meta's cross-check program. You've studied the Oversight Board closely and really kind of documented its creation. What can you tell us about how the board was originally envisioned versus how it's operating today a couple years on?
Yeah, thank you so much for having me. And it was great to hear Julie and Jamal's thoughts on this. And I have, I had a chance to look over the PAO before it came out and briefly and kind of to process it a little bit. And I'd say that it's probably one of, in my opinion, one of the strongest opinions that's come out of the board, and certainly one that is, as Jamal was kind of saying at the end, that it's not just to overturn Meta, that is kind of like a hollow type of way to go about kind of constructing a set of policy arrangements, frankly, that they are starting to give direction to industry. And I would say that that's actually that is something that's coming through in this piece. So there were three things that really struck me, just to get into the weeds for a second on the opinion. Crosscheck is this incredibly kind of problematic program that got set up for really good reasons, for probably really for reasons that are, just very practical, that like everyone's speech, as much as we want speech to be equal, everyone's speech necessarily does not have the same equal amount of reach. A lot of it has more reach. And in the same real world celebrity and kind of public figure, public policy facing kind of parts of the non-online world kind of have been recreated over the past 10 to 15 years on these big speech platforms. And essentially, that's one of the things that Crosscheck was made to kind of address, which like there are a lot of people who have huge number of followers, and we're seeing this all the time, that say terrible things or get targeted in terrible ways. And there needed to be some type of kind of way to address those concerns that kind of gave them recognized those realities, right? Whether they're correct or not, just the fact that those realities exist. What the problem with Crosscheck is that it's not transparent. We had no idea how it worked. There were some white checks. And one of the things that the board really brings to the fore in this conversation is that essentially there were entire types of figures or entities that were exempted from the enforcement regulation of the community standards. They were just they didn't apply to them. The rules didn't apply to them. So you had people like Neymar, the Brazilian footballer, is the best example, and probably the high watermark for poor behavior, because he had literally signed an economic deal for live streaming his games with Instagram and Facebook. And so the reason that non-consensual porn rules were not applied to him when he tweeted, or when he when he posted a number of images from his former partner who had accused him of rape, that a lot of these were not applied to him was in part because he had a deal with Facebook, and that's not right. That is a very high watermark of something that is not how this system should work. And I think that is one of the best things that the board pulled out, was here, listen, these are the types of people that should get your special protection. There should be special protection for journalists, people who do human rights abuses, that have high concern for human rights factors, that they kind of go through all of this, public officials, political office candidates, those types of things. You may kind of give special protection to people who do have commercial interests that are represented on the site, but you should not, and I really liked how they kind of do this, should not give any type of pure exemption from the rules to anyone for any reason. And I think that that's one of the first times that we've heard that. The second thing that I thought was huge was essentially them saying that government affairs and public policy had to be split off from the entities that were doing the content moderation work. And this is like a very classic separation of church and state, separation of editorial and the business side, and like in a media corporation type of idea. You just don't want those two things doing business with each other. They should not be considerations that could take it into account. And so those are some really specific recommendations. They could have said something, the board could have said something kind of mealy-mouthed, like, do something just in line with human rights, or something that's better than this, right? And like, let's be honest, that wouldn't have gotten us anywhere. Like, there needs to be stronger signals about what to actually do. And so this was, I was very impressed, and I was slightly concerned, to be honest, leading up to this, that cross-check would be gotten rid of completely, because I do think it serves a pragmatic function in the ecosystem of content moderation. And so overall, I thought that it was a very strong opinion. And it is, I think to your question about industry and the future of the board, I think that Jamal hit it right on the head when he said that, like, they're sending signals to industry. And I think especially in kind of the environment we're in right now with Twitter and other places, that this is an especially needed voice. So I was happy to see it.
Yeah, thank you. And I really want to come back to this question about sort of lessons from the oversight board experiment for kind of the broader content regulation discussions. But first, I also want to loop in Devin to also talk with us a little bit about kind of what's going on the other side of the coin with politicians and people who maybe face more scrutiny for their speech online. There are a lot of angles to this questions about how political candidates and politicians might be treated on social media. So we see, as we talked about on the first panel a little bit, the Florida social media law it has a number of elements to it, but one of the things that it prohibits is willfully deplatforming a candidate for office, and was really kind of drafted in response to concerns both about Trump's ability to post on social media services being revoked after January 6th, but also kind of scrutiny of how social media companies could decide a sitting candidate no longer can post, no longer can have access to that particular audience. And we've heard about the cross-check system and the Facebook program for ensuring that politicians' posts aren't inadvertently removed from their service, and making sure that that's not kind of happening by accident or through a false positive. So Devin, you co-authored research recently published by CDT looking at the other kinds of experiences that at least some candidates have online, looking at political candidates and particularly women of color, and the kind of abuse and harassment that they actually face, and how that affects sort of their ability to run for office and to participate in online conversations. So can you tell us a little bit about your research and what you found?
Sure. So I'll just start by saying that we know that I think that the cross-check program, at least the way it's set up, is sort of different than what we found. It's not the same construction when you're a political candidate and you are facing targeted harassment. I don't think it was structured in a way that was meant to address that specific issue. So just sort of cabining that there, and I'll return to that later on. But in terms of our findings, we sort of know generally that over the past several elections, the number of women and women of color seeking political office has increased, but that has also been accompanied by an increase in online harassment and abuse, including, obviously, as you mentioned, targeted mis and disinformation campaigns that are targeted toward them on the basis of race, on the basis of gender. And while these numbers are growing, we know that women are very much still underrepresented in politics. Only 10% of candidates in 2020 who ran for Congress were women of color. And we know that they still face a number of significant barriers into representative politics, including the online targeted harassment and abuse. And in terms of implications, that lack of representation definitely challenges the quality of our representative democracy. I would say that's the sort of direct link to the conversation that we're having now. And so I'll talk a little bit more about some of the main findings from our report, which is titled An Unrepresentative Democracy. And so one of them is that women of color candidates in the United States encounter mis and disinformation and the worst kinds of online harassment at higher rates than other candidates. And just to drill down into some of our more granular results from the content analysis we performed, which did focus on Twitter from 2020, we found that women of color were twice as likely likely as other candidates to be targeted with or be the subject of mis and disinformation. We found that women of color were more than 4 times as likely as white candidates and twice as likely as men of color candidates to be targeted with violent forms of abuse. They were also more likely to be targeted with or be the subject of posts that combine mis and disinformation and abuse than other groups of candidates. And they were also more likely to receive sexist and racist abuse than any other group, including white women in the case of sexist abuse, and men of color in the case of racist abuse. And finally, they were at least 5 times more likely than other candidates to be targeted with tweets related to their identity that focus specifically on gender and race. And I could talk a little bit more just about some of the responses that we got from candidates, if that would be helpful, just to kind of put some of this in context. We interviewed a number of candidates who ran just to explore some of the effects from their point of view, from the point of view of women of color candidates, and to really understand some of the challenges that women face in seeking political representation. And first, I'd say that like many of the attacks that interviews reported were very severe. We learned about some of the degree, but we also learned about the degree of resolve and coping that the participants displayed in the face of these attacks. So that's a really important takeaway that was something that we wanted to highlight, because it is not as though these kinds of attacks sort of preclude women from running altogether, but it does have an impact on who stays in a race, what kinds of costs they face sort of personally as they stay in a race, and obviously the likelihood of them dropping out. We consistently heard from interviews that from their perspective, the aim of the people behind the attacks was essentially to destroy their resolve. They thought that the purpose was to get them to internalize some of the abuse, to accept the oppression they face as women, and to drop out of politics, to get them to stop essentially taking up space in the political arena. And I think that came through sort of more often than not. And that they experienced a lot of trauma and felt dehumanized as a result of the disinformation, the heavy abuse, the violent threats, because they are personally the targets. So I think that kind of encapsulates some of what we could term as the responses that they had to what they were facing on some of these platforms. And then also I just wanted to kind of like interject some of the quotes that we got from them, just like one, and I'll leave it there because I know other people want a chance to kind of jump in here. But like one staffer that we interviewed, so we also spoke to communication staffers as well as candidates who ran, which really reflected some of the emotional costs that they sort of that they face as they sort of push back against this barrage of disinformation and violent abuse. They described their experience saying that being a woman of color, being young, that it was extremely disheartening. She sort of also went on to say that because the candidate that she was working for had previously been elected, that there were just a lot of personal, almost small town rumors floating about. So it just became extremely overwhelming and taxing for them as they sort of like continued on the campaign. And one candidate also described the emotional toll, saying that it was super emotional for them, that they sort of found themselves sort of like crying more often than not. And it was because they sort of knew that the attacks were about who they were, not necessarily their politics. And that was essentially the constant challenge, when it's not something that you can actually change, and it's not something that actually has anything to do with how you will govern, the kind of leader that you are, or the capacity that you have for leadership in general.
Yeah, thank you, Devin. This is it. I really recommend folks check out the report. I don't think anyone is shocked to learn that women of color face more abuse online, but the way that you all kind of studied it, documented it, and especially the kind of direct interviews with candidates themselves, I think really puts this very stark set of examples out about the real impacts and the real consequences when hate and harassment is just an expected part of what people who are putting themselves out there in public life, whether it's running for office. We've also heard from researchers, academics, journalists, plenty of different people who are kind of in the public eye and are facing racist and sexist and intersectional different kinds of abuses. So I want to also come back to that, but bring Matt into the conversation too. We could have each of you on for an hour all by yourselves. But so Matt, you've been thinking really deeply about different kinds of kind of policy responses, policy interventions in the online speech ecosystem, and you've been something of an advocate for tech policy experimentation and thinking about kind of different approaches or different things that we could be looking at in the US, as we're having conversations about content governance, both to address the kinds of abuse that Devin's been documenting and resolve some of the questions that were being brought up on our first panel today, looking at, maybe the Section 230 status quo isn't what some people want to see go forward, but what should the option be? So I'd love to hear your thoughts in general on kind of what experiments in law and policy do you want to see, but tying it back also to the conversation about the oversight board, I had framed it in kind of closing with talking with Jamal and Julie of, I've been watching the oversight board really as an experiment. What do you think of how that experiment is going? And do you think there are lessons learned from that could be useful in broader policy discussions here in the US?
Thanks so much, Emma. A lot there to unpack. And first, thank you so much to you and Jamal and Alex for organizing such an extraordinary event. I can only imagine how much goes into it, and I'm really grateful to be included. I think that my interest, or as you say, advocacy for experimentation, I feel like such a champion of it, comes in part from the experience that I had of watching lots of well-intended efforts that we had at Facebook turn out in somewhat different ways from what we might have expected. I don't think that's unique to Facebook or unique to industry. I think you can look at policymakers and you see the same thing. I don't think policymakers who pushed for SESTA-FOSTA reform, for instance, thought it would harm the sex worker industry, which is the industry it was designed to protect. Now that industry claims that it has been harmful and advocates for its repeal. So there's lots of examples, I think, across industry and policy of what we imagine an outcome to be, not actually being that outcome. And I think that counsels in favor of an approach to policy in the tech landscape where we approach it with curiosity instead of certainty. And curiosity means that we're trying to learn information that will help us to improve policies, whether that's industry policies and products or whether that's policies on the regulatory side. Some people say when you talk about experimentation, we can't do that in tech because it's so important and people will be harmed. And I think that's certainly a view that I think is important to be thoughtful about. Devin, I think, has detailed lots of different ways that certain forms of experiments, I guess you could say, have harmed people in meaningful ways. And I think that's really important. But we have experimentation in lots of industries where the stakes are high. Medicine is one example. We use experimentation to trial different vaccines, for instance, where the stakes are literally life and death. And people don't say we shouldn't do that because the stakes are high. They say we should encourage experimentation so that we get innovation that we need to see that will make our lives better. I think that would be an important thing in the tech sector. So then the question is, I think, what would the elements of experimentation be? I think the first one, and it's a key one, is to have time-limited public policy. So instead of just passing a bill like SESTA-FOSTA reform, for instance, where it will proceed into the infinite future unless it's repealed, and I think the likelihood of repeal is relatively low, passing bills for set periods of time. So where the trial period might be 6 months or a year or 2 years or 5 years. And during that time, we can actually track the performance of the legislation in practice and see how it's actually performing. That means we need to gather data. That means we need to identify what data would be the important data to actually collect. We need to figure out what will help us to tell the story and evaluate success. We need to figure out how to share it. So how can industry share it with researchers and other third parties and ensure that researchers and platforms are protected in the sharing of that data. I think it's also important that we make some attempt to understand the causal relationship. So we should link provisions of policy to specific criteria. In the Florida and Texas bills, which you talked about previously, we can think about things like, does a common carrier requirement actually result in less content removal, which is ostensibly the reason that the bills were passed? Does it result in less space for user-generated content? So does it actually have an effect of suppressing speech? Does it result in more hate speech? Does it result in more impact on vulnerable communities? Does it shrink the opportunities for competition between smaller platforms and larger platforms? I think those are the kinds of things that we should track. And I think while I'm skeptical, for instance, the Florida and Texas bill will have a positive impact, I don't know that for certain if they end up being upheld by courts. And I think it would be really important to track it so that we can learn about their impact over time. It's also important, obviously, that there are reporting mechanisms. So third-party audits or regular reporting or cost-benefit analysis that looks at how the bills, how the legislation is playing out in practice. And then I think sort of culturally, an approach that's experimental means moving away from such an intensive focus on accountability and liability and toward more of a focus on learning so that we can learn how to make policy and products better. I think there are many different parts of the ecosystem, certainly companies that shy away sometimes from doing things that are oriented around learning because they're worried about liability. That could mean legal liability, but it could also mean press liability, that they're worried if they test something or do something in a certain way, they're going to face a lot of negative press attention. And that results in being more closed and being less open to trying new things and sharing information that I think might help people to learn. On your question about the oversight board, I think I'm really interested in hearing more about Kate's take on this, because she's really the expert and I'm not. Part of the way that I sort of try to approach it is by thinking about, in my role as a consultant, for instance, and advising other companies, would I advise other companies to implement a similar model? And my instinct there is that the answer would be no. And I think thinking about why it might be no, then the question is, well, what's the criteria that we might use to evaluate the oversight board? I'm really curious about what Kate would outline as her set of criteria and then how the oversight board performs against that criteria. But a couple ones that sort of come to mind for me are, do they provide feedback that improves performance? And that's, I think, probably the key one. Like, is there feedback that results in changes in the systems that actually results in better outcomes? And I was inclined, when I first read the advisory opinion, my first instinct was no, that it wasn't at a sufficient level of granularity to really provide actionable mechanisms that would change behavior in meaningful ways. But I think in Kate's opening, and then I pulled up the opinion and started looking at it again, I think she convinced me that I think I'm wrong about that. I think there are, maybe that's not comprehensively actionable, sufficiently actionable, but there are lots of things in there that are actionable in ways that I think are really interesting, including in line, I think, with the general thrust around experimentation, like one of the recommendations around transparency is measure, audit, and publish key metrics around this cross-check program. That's the kind of thing that I think is really valuable. And so maybe they are providing feedback that improves performance. A second question would be, do they increase credibility of Meta's decision-making in some way? Do they increase trust in the institution? So you could look at trust of the oversight board or trust in Meta in its content moderation decisions. I think the answer there is probably no, although everybody else on this panel, including our moderator, knows way more about that than I do. So curious about your views, like, has it actually increased trust in the institution? What I see is a lot of people thinking about the oversight board as an appendage of Meta in a way that is problematic, even though I think Meta set it up to really, like, in a really good faith way to try to establish independence. So I'm curious if my sort of knee-jerk reaction on that is accurate. And then the final criteria, I think, is setting up an oversight mechanism create some sense of shared responsibility. Like, do they get some relief to the platform? The platform, without an oversight board, is just alone making decisions. With an oversight board, is there some sort of shared responsibility where now they can say, it's not just us, this is actually, these decisions are made in concert with other people, or reflecting opinions from others? And I think the answer there is no. Like, I don't think that Meta, my guess is that it doesn't seem to me that there is much relief from the burden of decision-making as a result of the oversight board's presence. And I think as a result of that, I would probably suggest other companies don't follow the model, but I'm curious if other people see it differently.
Kate, I'm happy to come to you next for kind of response. Matt asked you a lot of questions.
Yeah, no, I mean, so, okay, there's a bunch of things. First, a few things is that actually I quite think that that there are, the oversight board model is not going to be a solution for Reddit. Okay, like, there's just, like, that is not, like, there is these are, like, this is somewhat user generated content and product bound solution. Okay, so, like, if you're having a private company that is not allowing users to self-moderate, like, like you do in Wiki or in a Wiki model or a Reddit model or something like that, you have a centralized kind of commercial content moderation system. I think that the oversight board is a pretty great solution to start building in meaningful governance into these types of systems. I disagree that this wouldn't be a model for something like Twitter for that very, or something like Twitter or YouTube for that very reason. Like literally all I've heard for the past 7 to 8 years from civil society, from stakeholders, from individuals in my inbox who send me lots of messages when they get locked out of their account or their stuff gets censored, is like, listen, this is just unequal, it's unfair, there's no transparency, we don't know what's going on, this is this black box, the content changes, the enforcement changes, all of this stuff, right? And so like, listen, like courts aren't great models. Like the literal government is full of flaws and bugs, like, right? Like we can all agree it's like the best, least bad thing that we can possibly use to solve this. Is like my con law professor once said to me, it's like, no, this totally sucks and is completely flawed, but like, what else do we got, type of thing. And I kind of think that there is a certain sense that which like, listen, I think that it is one model in a giant ecosystem of online speech that is starting to become developed, that is starting to become ossified slowly but surely, and the norms of which are starting to become kind of ossified slowly but surely, that like has great outcome, like the oversight board sends some really smart signals. And I do think, contrary to kind of from a lot of the people I talked to at Meta, there was so much noise in the system of internally of trying to figure out what signals to listen to, that this is actually a huge moment of clarity for them. And sure, it's a bit of scapegoating, like so the oversight board told us to focus on this, but like, don't we want a multi-stakeholder organization that takes into account civil society and people who study these things, and the minority populations and the majority world populations that are affected by this to be the ones that are kind of weighing in, rather than it being a bunch of like boy kings in a boardroom? I think that there is a certain point at which, listen, it's not going to be perfect and it's going to be flawed, but there is like, I think from everyone I've talked to at Meta, including the governance team, which is now tasked with like setting up and like kind of trying to implement, deciding how they're going to implement these suggestions, this is a very welcome thing. The other piece of this that I think is kind of under discussed is that there's a lot of politics in any large organization. And like a lot of people at Meta, especially at the lower ranked things that don't have a lot of cachet in the C-suite or are not super like kind of juiced politically, have good ideas that have criticized things like cross-check for the last 5 years. And all of a sudden the oversight board doing this gives them some cover and gets their agenda kind of pushed forward in a way that is really important and gets people to listen to it, that have the power to actually make the change. And that is something that I'm hearing a lot of from within trust and safety people at the company, that this is like one of the side effects of the oversight board. I'm not trying to sound Pollyanna-ish in any way or overly optimistic about this thing. I'm really not. Like I actually like, this has exceeded my expectations. If anything, I was more skeptical, and I don't know, not every decision is perfect. They recently had a pretty bad decision, I think. But I do think that this is, I think that it's not, I think that I just spend a lot of time on the ground talking about this. And so like, this is what I'm hearing. And if I was hearing something else, I would definitely surface that. It's just that I'm not. I'm actually hearing that there is a system that is set up, this is the CDT, EFF, like Witness, all of these different places now have like actual organized places and transparent places to have these conversations, instead of, no offense, Emma picking up a phone and calling someone at Facebook and trying to surface the concerns of CDT. This is a better way of doing it. Now everyone knows that CDT is a stakeholder with Facebook, and like that's how it should be. And I think that that's actually really important. So anyways, that is a little bit like my pitch. But to your point, like, no, I do not think necessarily that the oversight board model is the best solution for all types of user-generated content platforms. I do think that it's best for large-scale, global kind of speech platforms for user-generated content, especially where political speech matters the most, where people are spending a lot of their time. But I will stop talking now.
Thank you, Kate. And to that point about appreciating the transparency, I will also say I am so glad that the Oversight Board in particular took up a case about internet referral units with its UK drill music case, because I and several others have spent the past like 8 years making the phone calls and having the one-on-one conversations and trying to raise it in public venues as a really crucial kind of question. That's not what this conference is about, so we'll set that aside, but boy, we could do a deep dive on that one. I appreciate, though, that kind of reflection of, in practice, what have we seen over the years actually shift the attitudes and shift the practices of companies. It also makes me think about a conversation we'll probably have on Thursday of FOSO about what's going on outside of the US, including things like the Digital Services Act and the kind of the new regulatory structure coming in Europe, and just how many more sides to the conversation there will be when you have a whole team of different regulators across Europe and the many staff within different tech companies all kind of in conversation with each other about what direction do these things go. But I wanted to come to Devin and then to everyone kind of with a question about transparency. Transparency really seems to be a theme that we're seeing across a lot of these different discussions as, if not a final end result of our policy making in the online speech ecosystem, a really necessary component. And I know that there were a lot of different responses, Devin, that you got in and ideas and recommendations from the people who participated in your study. I was wondering if you could tell us a little bit about what were the kinds of interventions or tools or responses from the companies that the women of color candidates in your study were really asking for.
Sure. So, well, everybody also said thank you. And even though we're colleagues, I also want to say thank you, Emma, for allowing us to be on this panel and talk a little bit more about this report, because I think it is really important and timely. And so thank you. And with that, so I'll talk a little bit about what the candidates mentioned wanting on platforms. I think that for them, they really focused on some of the controls that they lack for managing the abusive content on their pages. I think what they really focused on was the trolls and bad actors who were taking advantage of what is an open platform to misrepresent their positions on policy matters and essentially to spread hate. And so they asked for better controls to kind of really manage what constituents who were coming to pages that they manage would see, because they sort of saw the influence of others sort of controlling the narrative around their campaign and their positions. Other recommendations that they relate to us relate to what they described as sort of an imbalance in the amplification of positive content versus the amplification of hateful, bitter narratives that were targeting them as women of color political candidates. But I would also say that the report raises a number of other important recommendations that would also sort of tackle some of the threats that women of color candidates faced in terms of mis and disinformation. Companies could, for example, take steps to protect candidates and prevent abuse from reaching women of color candidates in the first place. For example, I think Kate mentioned this earlier, sort of offering tools for verified accounts or for accounts of candidates and public officials that would allow them, including women of color candidates, to quickly escalate abuse reports to specially trained moderators. They could also prioritize resources, as opposed to prioritizing resources towards protecting the speech of celebrities. They could prioritize resources towards enforcement of content policies that prohibit abuse and misinformation in the run-up to and after elections. And that would also include increasing resources needed to respond to appeals. I'll say that in our study, only one respondent, literally just one, reported having any success in getting the platform to remove content that was false or abusive. And in terms of your question about transparency, there are a number of things that we mentioned in the study that sort of relate to the ways that social media companies in particular could be more transparent, particularly about policies that prohibit content that harasses or abuses someone on the basis of their gender or their race. And they could really work to improve processes for all users by shifting towards, I think, greater transparency around their systems sort of generally. They could provide better information about how they consider gender and race in their policies and enforcement processes against mis and disinformation and abuse. They could also provide transparency reports around election mis and disinformation and abuse before, during, and after an election, and really give the public a holistic view into the content moderation and integrity operations within the platform. I think it would really help if that kind of reporting included a demographic breakdown of abuse and disinformation targeting political candidates, so that we could really sort of see some of these differences between different types of candidates. And lastly, I think something that was also reflected by the interviews that we did, if companies offered trainings for political campaigns on how to best use the platform tools to address online abuse, I think that would really go a long way to reducing some of the high costs that candidates face in navigating what is essentially a toxic information environment. And it could really improve the experience of running for office and ensure that fewer candidates drop out due to targeted online harassment.
Yeah, thank you, Devin. I also want to acknowledge one of the comments in the chat or the Q&A function, which everyone's encouraged to use to send in your questions, because we'll turn to audience questions in just a minute. But Ben Brodsky mentions actually having built a product for, or a kind of a service or plugin for people on Facebook to be able to moderate their own comments on pages, and the use that that people have made of that, including women of color and other minority candidates who really weren't finding Facebook to be responsive to the reports they were making, but were able to kind of use, a user empowerment tool. But Ben points out in the rest of his comment that these are the kinds of tools that you could want and expect Facebook to roll out site-wide, right? That you could see kind of getting implemented at the platform level and not necessarily have to be the sort of self-help tool. So on the one hand, it's great that those tools exist and are out there and that people are building them. But on the other hand, it is also yet another set of recommendations and requests and kind of product updates to take to a service like Facebook to say, so many people find this useful, why not roll it out more broadly? Matt and Kate, I wanted to see if either of you wanted to come in on questions about transparency or any of the other kind of things that we've been talking about just now.
I'll just really quickly add that I think that transparency is generally kind of a thinly defined concept, that we have lots of calls for transparency. I think people think that's going to be a solution to a lot of things, but like from anyone who's ever done discovery or any type of kind of document review, that like too much transparency without legibility can be very kind of damning to actually having a sense of what's going on. And similarly, like you kind of need a certain amount of privacy as an opposite. Like there's privacy concerns for users, obviously, but there's also privacy concerns for expression. Having an ability to kind of think through things and have kind of intellectual privacy, as Neil Richards would say, is essentially kind of is like a key component to like how we do things in courts and how we do things in other types of places. But I do think that like overall, having more metrics on these types of things, having specifics when researchers call for specific types of metrics, that is a very easy low-hanging fruit ask. And like post hoc metrics should not like do a lot of the things that the companies have in the past said that they will do, like enable like transparency. If we like, one of the big reasons that content moderation was a black box for such a long time that the company said was that like, well, if we release these rules, then people will know how to break them. But that's just like not a viable long-term strategy for any type of like giant speech project. And so I do think that like transparency, specifically the metrics, and like one of the things that I actually really hope comes out of this, by the way, which the decision really focused on, I think is under discussed, is where the money is going for content moderation across global markets. Like the US is 9% of Facebook's entire global entire global market base. The average rate per user in the US is around $68 per year for like advertising. The next closest market to that is the EU with $14. So when we're seeing things like why there is more content moderation in North America, and like, they were just asking kind of why there was this focus on the Western world to Julie and to Jamal, like the answer is like, frankly, that's where they're incentivized monetarily to put more resources. And I think Devon's like like example is like exactly right, which is like if we want to like use this for a source of good as democracy, we need to have some mandatory cost spreading measures start to get put in place. Those are kinds of things that would not, I don't think at first blush, you could tell me if I'm wrong, Emma, you dabble in this much more than me, like trample on kind of First Amendment values that would like, you know, that those are kind of consumer protection almost concerns that would like have huge effects. And so like, anyways, this is something that I think having more metrics around this could like finally move us to some constructive types of regulation that wouldn't just be these overbroad, non-specific kind of decency types of requirements that I think we have not been super productive so far.
I agree entirely with the value of additional metrics. I also agree with some of Kate's skepticism about certain forms of transparency. Everybody wants transparency. I think figuring out what that means in practice is really difficult. And there are a bunch of, she went into a lot of the, I think the practical challenges around it. I think one more that I'd add that I think I was not very sensitive to when I worked at industry, because I worked at a larger company, is how challenging transparency mandates can be for smaller platforms. So one thing that was surprising to me was that in a report that I did on potential Section 230 reform options, I had sort of a mild endorsement of the PACT Act, which would impose transparency and operational requirements on platforms. And I thought it seemed like sort of motherhood and apple pie of tech reform. Like, of course, we should do transparency. Of course, we should have better reporting functionality and appeals mechanisms. And I learned over time from interactions with smaller platforms, like not the Facebook, Apple, Googles of the world, about how challenging that would be for them and how it would put them at a competitive disadvantage relative to larger companies where, you know, larger companies can hire 500 new lawyers. And it's challenging for smaller companies to do that. I think we're going to see some evidence of that play out, which I hope we will track and try to understand exactly how it plays out with the Digital Services Act in Europe, because that imposes some of those requirements on the industry overall, but then has additional requirements for large platforms. My assumption, which may be totally off, but my assumption is that it will disproportionately harm competition. It will impose burdens on smaller platforms that are outsized relative to their size. And despite including additional burdens on larger platforms, those additional burdens will be easier for platforms, the larger platforms to bear than the smaller burdens will be for smaller platforms. I might be totally wrong about that, but I think that's an important thing for us to consider when we look at transparency requirements.
Yes, and if folks are interested in digging more into the questions about just how constitutional are transparency mandates, we will have a whole panel talking about those and other questions raised by the Florida and Texas social media laws tomorrow at, don't want to get it wrong, I think it's our first, tomorrow at noon, sign in tomorrow at noon. You'll definitely see that panel at sometime between noon and 2 p.m. I think starting at around 12:30 tomorrow. I want to go to a question that we came in, or a kind of question / comment that came in the Q&A from Bruce Rockwood. I think really responding, Matt, to your idea about sunsetting laws as like when we're thinking about experimenting in different approaches to regulation, maybe not having a hard and fast rule that is the be all end all forever, but having a sunset built into a law. And Bruce raises some questions, I think basically about the political feasibility of that, saying that sunsetting laws may be the price of their enactment. When time comes for renewal, they become bargaining chips. And as we saw with the assault weapons ban, change political landscapes means that they can then go away forever, and that it's not necessarily a sure thing. Curious folks' thoughts on that. Like how do we think about both the dynamic kind of policy and political environment around legislation versus the kind of real logjam that Congress is in, for better or worse right now, around these issues, where it seems like few, if any, things can even get to the point of having that conversation about should it have a sunset clause?
Yeah, so I think one of the valuable things about experimentation is, at least in theory, it should lower the stakes, and so then we'd see more tech reform, and we'd be able to enact more reform and then shift reform over time, as opposed to just being at the logjam that you described. It seems like there's some possibility now that a bill related to competition in journalism might pass in the lame duck. We will see, but there has been rumor of tech reform now for a decade, and the number of actual reforms to regulation in the tech sector has been very much closer to zero than a substantial number. And so I think there is some value. The price of enactment, you can focus on price or you can focus on enactment. I guess part of my thinking is to focus on enactment, that there's actually getting reform across the finish line is helpful. I have toyed with the idea, like there are lots of different ways that you can have sunsets. And I think that's an interesting thing to try to get creative around. Like you can have bills that where there's an opportunity for a sunset if there's some sort of, but there's an opportunity for a sunset if there's an affirmative vote to sunset the bill, but that it would continue on. Or you could have that there's some kind of third party audit committee that kind of includes a recommendation in the report. Whether it sunsets or not is rooted in the recommendation of the third party entity. So if the third party entity says Sesta Fosta is not performing as expected or as we wanted it to, it could sunset. If the recommendation is in the other direction, then it continues. I assume there are like lots of logistical, political, legal issues with those kinds of things, but I think you can probably get creative around it to set defaults in a direction that is constructive.
So I think tying back to our theme for FOSO this year, all about the Supreme Court's pivotal term, we managed to go most of the session with talking about the Oversight Board, which is kind of sort of the Facebook Supreme Court. But the US Supreme Court is also taking up a bunch of cases, or at least 2 cases so far, and likely a couple more before the end of the term, really looking at some core questions around the legal frameworks around content moderation. And so, we only have a couple minutes left, so I'll throw a couple of the different cases at you, and I would love to hear from folks what kinds of implications you think these decisions might have. So for example, if the Supreme Court upholds the Texas social media law that generally prohibits online services from removing content that is not illegal, so that might include things like hate speech or disinformation or harassment. Or the court might decide in the Twitter versus Tomna case that a site could be found to have aided and abetted an illegal act by having a general awareness that a terrorist group was using its service and that the service failed to block or remove all of that group's content. Or in the Gonzalez case, in Gonzalez v. Google, the court might decide that Section 230 does not shield the targeted recommendations of content that an online service might have. Those are a couple of big different potential changes to how the law around content moderation works. I'm curious for your thoughts in our about 4 minutes remaining of what kind of implications you see, or are there particular cases or particular decisions that the court might take that have you particularly worried, or conversely, where you think there might be some opportunity?
Devon, go ahead, please. I've been talking too much. I just didn't want to put you on the spot for the Supreme Court.
No. I just really wanted to speak to some of the consequences that might flow from a decision like this. I think that's sort of, as not an attorney, and proudly so, I'm very happy to focus there. I think that obviously in this case, the focus is on the legality of the content, but I wonder if there is room to sort of focus on the consequences and impacts associated with removing abusive content. I think that we sort of know that a lot of the most severely harmful content is legal. It is legal. And the only reason it gets removed is because on a platform, it violates their platform's terms of service. So we sort of see the terms of service on this platform acting in ways that obviously the courts cannot. And I think that not removing some of this targeted harassment, particularly that's based on race and based on gender, really risks sort of raising the stakes on, I guess, or at least raising the likelihood that the quality of our representative democracy will degrade even further, even faster, because we know that one of the impacts is that it's especially intimidating a significant portion of the population from seeking public office, particularly in the case that we were mentioning in the study that we did, and also misinforming the public about women and women of color's capacity to govern. And I think that social media platforms are an important tool for women in public life, which is why the online abuse, the gender, race, and race-based targeting is directly linked to these sort of like democratic outcomes, these representational outcomes. So I'll stop there because I know we don't have that much more time, and let my colleagues kind of chime in.
Everything Devon just said was perfect. That was great. I think that that's exactly right. I think that, like, to use kind of Jack Balkin's free speech triangle type of notion, like, listen, there's a bunch of ways that you can get accountability. If you have a system in which the internet has loosened part of the power of the state to censor you, the government going through platforms to censor you is dangerous, and cozying up with government to censor you is dangerous. Going through government to get at platforms can also be dangerous, because obviously you just, again, don't want those two sides of the triangle getting closer and closer together. And the best way, and I think this is part of why I'm a cautious proponent of models like the Oversight Board, is like to actually take the private platforms that are hosting or not hosting the lawful but awful speech, and like basically deciding to do that on their own terms, but it can go and exist somewhere else in the meat space universe, or somewhere else in another platform, or do whatever. But making this kind of thing is like empowering the individual users and citizens on the side of the triangle to have governance over the private platforms is really, I think, where the focus needs to be, for all of the reasons that Devon just said.
Matt, any final thoughts?
They've said it so well. Nope.
Alrighty. Well, thank you all so much, Devin, Kate, and Matt, for a really great conversation. We covered a lot. There's still a lot more to talk about through the rest of the Future of Speech Online. But I just want to say thanks to you all, to our panelists throughout the day, and to all of you on the stream and in the webinar for listening and asking questions. A particular shout out to my colleagues, Jamal, Elizabeth, and Tim, who have been doing a ton of work on the back end that y'all haven't seen. But thank you all for helping this move very smoothly. And a special thanks to our captioner, who did not actually get to trade off with anyone in the middle of this, so handled a whole lot of really interesting but fast-flying commentary today. We will be back tomorrow at noon for another jam-packed day. Tomorrow is our legal deep dive into the cases before the court, and we'll have over a dozen experts sharing their insights on what arguments and outcomes we might see from the US Supreme Court in these pivotal cases. You can still register for the next 2 days sessions at cdt.org, or follow along on the live stream at youtube.com/senddemtech. Thank you so much for joining us, and we will see you tomorrow.